this very exciting set of issues in the admissions office. Right in front of your eyes, you should see my contact information. Please feel free to reach out to me at any point in time. I'm always happy to talk to schools, whether they're NAIS members or not. I talk to admissions people, heads, trustees. All the angry parent phone calls in the office come to me. I know when all of your admissions letters drop because that's when I start getting the first wave in the spring. So do please feel free to reach out at any time. I cannot be your legal counsel. I can't provide your school with legal advice. I do or coordinate all of NAIS's in-house work, and I work with our government relations team to track legal trends, both federally and to some degree in the states. So that job keeps me busy enough, so I cannot, again, be your legal counsel. But usually when you call me, I can give you a bird's eye view. I'll provide you with white papers. I'll give you sort of insight in what I've heard from other schools and sort of what some of the trends are in your area. So, again, feel free to reach out at any point in time, and just bear in mind that I can't provide you with legal advice. About today, we're going to talk about, sort of a bunch of different admissions issues. Karen was kind enough to share with me the list of things that several of you put into your registration forms, what some of the pressing issues are, and I'm going to try to address those the best I can, but feel free, at different points to type in questions if you feel like I'm not getting to the points that you were raising, and I'm happy to address them. I did want to show you the NAIS website a little bit. We revamped it about 18 months ago now. If you look in that green box, if you click on Learn, you're going to get this sort of little box next to it, and you go down under the Knowledge Center, and you'll see Legal and Legislative Resources. And if you click on that, this is what you get. Actually, there's an updated version now, but this is where most of the legal white papers are. So if we talk about something today and you want to look for it, you'll find it here most of the time. You can use the search engine too, but this will give you a broad list. Here you'll find a piece on the ADA in independent schools, questions you can ask in the admission process, that sort of thing. So let's start just a little bit with how all of the legal issues fit together. In the federal structure, we have the Constitution, which delegates the authority to Congress to pass legislation. And those are kind of like the big base laws, and the legislation always has to tie back to the Constitution in some way. And then the Congress appoints the agencies with the authority to pass regulations that really help implement the legislation and provide greater guidance. And then you've got the federal courts, and then you've got administrative courts within the agencies that are interpreting the regulations, the legislation, and the Constitution. Those are sort of the big federal things, like the ADA falls under that, the Family Educational Rights and Privacy Act falls under that. There are big non-discrimination laws that fall under the federal structure. But then you also have the state laws. And states usually have the same structure, more or less. You'll have a state constitution. You've got your own capitals that have your own houses. You've got your own state agencies, and you probably actually interact with them more in some ways than you might interact with federal agencies. The states can raise a floor on a law. So you've got the Family Educational Rights and Privacy Act. Under federal law, it only applies if you take funding from the Federal Department of Education. But states can say, that's a pretty good law. We're going to require all schools in the state, public and private, to meet that law, regardless of funding, and they've got the ability to do that. So in that way, they're raising the floor. They can't do the opposite and say, even if you take federal funding, FERPA doesn't apply. A big area we see right now with this is non-discrimination laws on the basis of sexual orientation. In some states, this is becoming a lot more common. In other states, not so much. But there is actually no overarching umbrella federal law related to non-discrimination on the basis of sexual orientation. Today we're going to talk about a couple big federal laws, but we're also going to get into some of the state issues because I know some of those are the ones that really impact your day-to-day life. In the states, it's a little bit harder for me to tell you exactly one way or another how something's going to go, but I can give you ideas on how to think about it and what some of the common laws are. So let's start at the beginning. Here's one scenario that we've seen schools sort of wrestling with over the last 2 or 3 years. You have a fabulous family that has 3 children applying to the school. The parents are originally from Vietnam, and in talking with them, you've had trouble putting together a timeline about when they came to the States and why. You know that the youngest child was born here, but you're pretty sure the first 2 were not. Is this a problem? So for many schools, you're looking at this and you're saying, okay, are these students U.S. citizens? Are they not U.S. citizens? Can we even ask that question? Does it, how does it impact our school? You can't accept these children. You have no, generally speaking, no affirmative obligation to ask families if they're in the country legally, if the students are in the country legally. For some schools, if you participate in SEVIS, which is your ability to sponsor F1 visas for students, international students coming to the country, this becomes a bigger question because you're wondering, well, what if we get audited through the SEVIS process? What if we run into issues with the immigration agencies? And at least what they've said on the phone and in sort of informal guidance is if you have illegal students in your schools, that shouldn't jeopardize your ability to sponsor visas. Of course, they haven't come out and said that directly, specifically, at least not that I've seen or even that I've heard of. Those are some of the things you think about. The really big question for these students becomes a financial aid issue. And somebody raised this when they registered for the program a few days ago. And it does become an internal policy issue. Should school financial aid funding be going to both international students who might be here on a visa or students who are in the country illegally? And you have the ability to set that, to set those policies. You might have families that want to create specific scholarships for these students, but that's generally going to be an internal decision as opposed to one that's going to be set by state or federal laws. The other thing to be aware of, too, of course, is that for some of these students, when they get into higher education, it's going to trigger other issues. They might not be eligible for in-state tuition. They might not be eligible for certain federal grants and federal loans and things like that. So these are all issues to bear in mind when it's coming to look at a situation like this. But again, this is a scenario that I'd say 3 or 4 years ago it would only come up once or twice, and now schools are seeing this on a fairly regular basis. We might see some relief as immigration reform sort of keeps moving very, very slowly through the House, through the Senate, trying to move it along, but I don't think we're going to see any relief anytime soon. Karen, are there any questions on this one?
We don't have any so far, Deborah, so you can keep moving forward. Thank you.
Okay. You have a great prospect who would add a lot to your school community. She speaks 2 languages, plays 3 sports extremely well, and sings like a bird. She's very well-rounded. She has also applied to your 3 competitor schools. You have all previously agreed that you would stick to your individual financial aid formulas, but the girl's mother is telling you that if you can give her $2,000 more in aid, your school is her first choice. You can't really do this without violating your state high school athletic association financial aid policies. What do you do? First question here is, if you note this, this fact pattern talks about a agreement just to stick to the individual school formulas. Something to bear in mind is that schools may not agree on one financial aid formula. Higher education, specifically the Ivy League, got into a lot of trouble doing this, I think it's about 15 years ago now, maybe a little bit longer. And it's an antitrust violation because basically what it does is it sets the packages for these students. And they want to see competition between educational institutions. So that's the first thing, but you can agree, okay, we're going to follow our own formula. We're going to follow the same formula for our athletes as we are for anybody else. Can you offer more than you usually do? Yes, you can. Generally, you're going to want to be able to document what your reasoning is behind that. And again, you start to run into these state athletic association rules, at least in some parts of the country, that have very firm requirements for, whether athletes get financial aid, why they get financial aid, what that formula might look like, what you might be taking into consideration. They're pretty careful about not getting into how you're weighing things and the like, but they have a lock-in a little bit on those financial aid requirements. An interesting case that I'm watching pretty closely, there are 2 situations right now going on in higher education. There are 2 different cases. One is at Northwestern, and I'm sure you've heard about this, where the players at Northwestern are trying to unionize. They've got an initial review by a regional director there that has said yes, they can unionize. The NLRB, the overarching board, is going to look at it, and most people seem to think they're going to rubber stamp that and move it through. It's not a guarantee, but it's interesting because it's sort of saying, well, this is a big enough financial push for higher education, and they get enough money in their student aid packages and things that they should be considered employees. The other big case that's going on, if there's an antitrust case that's been filed in New Jersey, and it gets into the requiring the students to sign the rights away of their likenesses and their numbers and all these other things, and they can't get any further compensation for their participation in sports and higher education. That case is going to have a few different twists and turns, I think, coming up, but the combination of these cases could have an interesting effect on particularly the high school state athletic association rules, how we look at financial aid at our level, and particularly in the areas where sports are huge and we're seeing a lot of financial aid being given to athletes. So bear that in mind going forward. Keep an eye, don't violate antitrust laws between yourselves as it stands. If you're making exceptions, being able to document that, making sure that you're not discriminating in one way or another if you're making those adjustments. But then keep an eye on these cases because they very well might impact what happens in our own sort of state athletic association world. Karen, any questions on that front?
Actually, Deborah, we do have two that came in, if we can address those. The first is, Hillary is asking, can we ask if a student is a citizen?
I think in most states you probably can, but in a lot of, I think there are at least a few that that you might not be able to. It's going to depend on state law. There's nothing in the federal laws that are going to, raise that issue for you one way or another. But I know a few states have at least looked at that, and I haven't tracked that very carefully. So that would be something to check on your state level. And frankly, higher education is very good at tracking this particular issue, and they're really good to reach out to sort of your local colleges and universities and see sort of what they're doing on that front.
Okay, thank you. Christian is asking, are schools legally allowed to ask about learning differences and require families to submit documentation about those learning differences as part of an application process?
And we're going to get to that question.
Okay.
Okay. Is there another one?
Yeah, we just had a couple more come in. Adrienne is asking if a school can ask for a birth certificate to verify age eligibility.
Yeah, that kind of documentation is generally acceptable. Interestingly, I got a question from another school about whether it's a good idea to keep birth certificates or keep a copy of birth certificates. That's something you kind of have to be aware of in terms of the security of the information. As identity theft and other things becomes bigger, having those base documents, a notarized copy or whatever within your files becomes a little bit harder of an issue. But you can require documentation for, particularly for age eligibility and that kind of thing.
Okay, thank you. We have one more from.
And you should obviously.
Oops, sorry.
Go ahead.
We have one more from Julie, who's asking, when you violate your own policy in granting an award higher than the third-party assessor, aren't you ipso facto discriminating?
Generally when we speak about discrimination, you're looking at protected categories. It depends on, it really depends on the circumstances. You really don't want to violate your own policies because somebody's always going to ask you why. And, depending on, who the person is you're discriminating in favor of or who might be losing out by the way that you're applying your policies or the way that you're circumventing your policies, then you can be opening yourself up to a discrimination type claim. But whether you're discriminating, against somebody or a particular class depends on whether they're a protected class. That gets into sort of race, religion, disability, other categories that we're all pretty familiar with. But discrimination, generally as a term of art relates to, those particular categories.
Okay, thank you. I think we can move forward.
You worked hard to get the school to accept a student with a seeing eye dog for next year. The dog passed away over the summer. The student has recently informed you that she is getting a seeing eye horse. Is this a problem? I love this one because I'm a huge horse person. Seeing eye horses under the ADA regulations that passed a couple of years ago are actually going to generally be okay as service animals. They don't have a full service animal designation under the regulations, but particularly schools on the East Coast should be aware of this because these horses are miniature horses. They're originally bred for work in coal mines and that kind of thing. And the upside of seeing eye horses is that they live so much longer than your average retriever or lab or German shepherd. They live for about 30 years. And so you're going to start seeing more of these. I've already seen a couple in airports. I've had a couple friends see them on airplanes. You see them in different places. Be aware that this is coming because, of course, the conflict with seeing eye horses is that they have a lot of dander and they can kick up a lot of allergy issues, and you're going to get into sort of a balance between the student who needs the service animal and the student who has, severe allergies to the animal. So know that that debate is probably coming to a school near you sometime soon. These are just some of the ADA regulations that you see in front of us. They're sort of physical plant issues. Some of these have been pushed off a couple times, but just know as you're looking at the accessibility of your campus that there might be more that you have to do here because these physical plant regulations went into effect not too long ago. And then next up on the ADA front, know that there's a lot of movement on the website front. The admissions office is always very closely tied to the website, and as we're getting into electronic view books, electronic applications, electronic enrollment contracts, we're going to be looking at more accessibility through our website, so making sure that things are readable with an e-reader, making sure that there's closed captioning on videos and things like that. Really be aware of the accessibility issues as you're launching your new websites and moving deeper into that area. Are there any questions on that one, Karen?
No, we're good to go forward, Deborah. Thank you.
Okay. You have a new assistant business officer whose main life objective seems to be the school's record retention and destruction system. You would love to clear out the 3 rooms of file space the old admissions file take up, but where do you start and what can you get rid of? And this is our first survey question, Karen.
Okay, I've launched the first survey, so please select the option that most closely approximates what you do. We have about 80% of the votes in, so please finish up your voting and we'll go ahead and close the poll in about a minute.
This is a very key issue for many schools, and I will say that most of this is going to be based on, theories of liability in the admissions process. So there's nothing, generally speaking, that requires you to hold on to admissions files for a particular period of time. In the employment context, there's a period of time you're supposed to keep applications, how long you keep an employee file, those kinds of things. Specifically with admissions files, that initial application that comes in, there's just not, there's not as much regulation in this area, so you do have a fair amount of discretion. At the same time, you have to be aware of the kinds of suits that can be brought through the admissions process, and a lot of them relate to the discrimination front, and they can relate to the current class that you have, or somebody can bring a lawsuit going back many years trying to look at the patterns of your data. Karen, do you have the poll results?
I actually do. They're up on the screen right now. The keep all admission files for a multi-year period of time was 68%. Keep all admission files for a period of time except recommendations was 20%. Keep for accepted students and general contact info for others was at 6%. Destroy all but basic info within 6 months was 4%. And who knows what's in those files was 2%.
Excellent. And and I think this is a pretty standard spread. And it really, again, because you're looking at, what kind of discrimination lawsuit might be brought, and that's usually what they're looking at. Sometimes it's going to be tied to a lawsuit against another school, for what was in a recommendation or something like that, which I think is why a lot of schools tend to destroy recommendations earlier than, say, the entire admissions files. But you really want to work with your legal counsel to say, okay, what kind of liability might we have here? Actually, the first thing you should always say is, here's what we want to do. Does this make sense relative to the kind of liability exposure we have? And what would the attorney want you to have in the event of a lawsuit? And what does that statute of limitations, what does that window when you could potentially be liable look like, so that you know how long to hold on to those records? You know, and when you look at these records, you've got the general info, and a lot of schools will keep that information year over year. So if somebody reapplies, you know, you've already got them in your system. You know, grades or something else that you might hold on to just because that way you've already got it and you're mostly updating the file. Recommendations in the interview notes tend to be something that schools seem to, you know, destroy sooner rather than later. But again, it's sort of, you've got a lot of discretion in this area. But, you know, you can look at sort of the groups of information, how you organize it, and then sort of the in, not in, wait list, and how you keep that information. And you can differentiate. You don't have to do the same thing with all the files as long as you've created a functional protocol and you're consistent in how you do it. If you do destroy it, make sure that you've got a reason that you do it. It's well documented, because that will help you in the event of litigation to say these documents were destroyed in the regular routine business of our school. This particularly helps you if you've got electronic records, but this again is part of the school's overall document retention and destruction policy, which is required for basically all corporate entities, including schools, under Sarbanes-Oxley. When people were registering, they had a couple questions about electronic records. Just because you have electronic records doesn't mean that you should keep everything that you've ever received in your entire life. I know that we all probably have emails that go back to, you know, 1998, 1999. It's not necessarily a great policy, because if a lawsuit comes up and say they're trying to identify a pattern of discrimination or whatever, you will suddenly find yourself looking at admissions files for decades. It can go on and on and on. And, you know, you just want to be aware that while electronic files they're great, they're easily searchable, they're easily accessible, they take up less physical space, know that by their existence, it's just going to require you to go through it more in the event of a lawsuit, and if you have to go through it. So the next step in this is you've decided to keep all of your admissions files for at least 3 years. You know, and the standard among a lot of schools tends to be about 3 to 6 if they're going to keep sort of an admissions file of some kind, and then they fold it into either the main, you know, continuing file for the student, or, you know, they get destroyed. However, your schools believe in giving students a fresh start and limits access to these records to those involved in the admissions process. One teacher is demanding access to records for all of the incoming students in her 4th grade class. What do you do? These internal access questions, you can set these policies. Be aware that if the Family Educational Rights and Privacy Act does apply to you, if you take funding from the Federal Department of Education, or if your state has something that requires you to meet those things, you do have certain access tracking requirements that you've got to do. You know, you need to be able to document who accessed it, when that happened. A lot of schools will get into why they were accessing it, because under FERPA, you're supposed to limit access on a need-to-know basis. And that's generally a good rule of thumb across schools, period. You don't want somebody just randomly going through student files, obviously. But it's also, you know, the school can make the policy that we don't think that teachers need to know this information because we believe in the fresh start of our students. There might be exceptions to that. You know, if a student has a learning disability and you need to kind of have the teacher go through that and have a meeting about what some of those students' needs are to provide reasonable accommodations. But this is an area that you can have a lot of control over inside your schools, and schools do make different decisions here in terms of cultural fit. And again, the same applies for electronic format. This last piece can be a little bit tricky for schools in terms of who has access and making sure that those access points are consistent. Okay, you are in your 2nd year of an international student program. All 12 of the students are from Asian countries, and all are in some form of a homestay scenario. For the first part, you have 4 students who are staying with a relative who came to the country to stay with the girls. You have a call from the state of New Jersey, so you're in New Jersey, saying that this is a violation of the New Jersey dorm statute and the house is not up to code. And Karen, this is our 2nd poll.
Okay, the poll has now launched, and I'll leave this open for about 1.5 minutes if you'd like to cast your vote.
Super. Again, with, you know, these international students, as you all probably know, I mean, in the admissions world, I know that everybody's talking about this. There's been a huge influx of international students in these quasi-boarding homestay programs. while it's not a bad thing to get into, it's great in terms of global education, bringing more students to your school, diversifying your population. There are a lot of cultural and process issues you must be aware of, and there's a lot of liability going on here. If you had to ask me the top 5 things that I worry about at night, it's these little mini programs that are popping up around the country, and it's just generally not for the meek. The first issue for a lot of schools is it's going to be sort of the enforceability of that enrollment contract. Before you even get into this admissions world, you really want to look at, okay, are we prepared to, is our contract strong? Do we know that it's going to be enforceable? You might need an international version of your agreement. Looking at different payment terms, looking at potentially translating your contract into whatever languages you're going to apply as students start coming to your school from different countries, so parents are fully aware of what the contract says and what it means. Karen, how are we doing on that poll?
We have about 82% voted, and I'm going to leave it open for a few more seconds and then close it up and share the results.
Super. Particularly if your enrollment contract is an electronic agreement, you really want to look at the enforceability of that agreement in other countries. Work with your legal counsel to make it more enforceable either within the country of the parents that you're contracting with, or enter into a contract with somebody else. You can get into a corporate guarantor. You can get into sort of other structures to make it more enforceable. Look at requiring payment up front, because if you're going to have a hard time enforcing it in a foreign country, it's going to get very expensive. And it might be that potentially you're requiring the full payment of tuition before the student comes to campus. Karen, how'd we do?
Deborah, the first question, we were a boarding school, we've had them forever, is 42%. The next highest percentage was no, we do not have a boarding program at 28%. Yes, it's very small and someone else deals with the details was at 19%. Yes, we have launched a new program with homestays, is 8%. And yes, we have a program, we've created a mini boarding model, is at 3%.
Super. And I think this is pretty consistent with what we're seeing around the country. If you're not in this mode yet, you might find yourself getting there. The other mode that I didn't throw out there that I've seen in a couple parts of the country now are schools kind of pulling together and having one boarding facility. Sometimes it's run by a third party, sometimes the schools are running it together, but it basically creates a residential hall that several schools are leveraging all simultaneously. All of these models can work. There are good versions of them out there, but you've really got to be aware of what some of the potential issues are. You're seeing some of the enrollment contract issues up in front of you now. When the family is setting up housing, this has come up as an issue for a few different schools. It's not a free pass to just saying the family's taking care of it. You really need to know if a student is coming to the country that they're in a good scenario. I mean, it's one thing if they're on a dependent visa with their parents, but if they're staying with an aunt or they're staying with somebody who's watching out for 5 or 6 kids at different schools, you really want to know what some of the details are behind that. You want to make sure that that local person has the authority to make decisions on behalf of the student. And you want to be clear on what's going to happen if that situation doesn't work out or it's not what the family tells you. One school had a scenario where a student came over and they thought the student was at an apartment a few blocks away with a guardian of some kind, and come to find out that the student, who I think was 14 or 16, was actually living by himself. They had just set him up in an apartment and left. So, you really need to think through the details and make sure you're having clear communications with the family about this. One host family has called to say the student staying with them is acting bizarrely, refusing to speak English, and keeps climbing out his window. He also keeps going into a younger child's room at night. This obviously gets into a little bit of the host family situation. From the front end, host family situations can work very well. A lot of our schools have used them for a long time, for international students and frankly for local students too. And we have schools that have 5-day homestay programs or whatever. Those have been going on since independent schools have existed. But you've got to be very clear about the obligations of the student's family, the host family, the school, and the student himself. What are the expectations, the payments, the authorities, and being aware that we have the full-time arrangements. The cost and responsibilities for vacations and breaks and student spending and that kind of thing. You really want that homestay handbook, and you really want somebody at the school who's watching out for this, checking in with the students, checking in with the families, and really monitoring how this is working. And you're going to have a family selection process too. Questions related to who is in the home, sleeping and living arrangements in the home, transportation to school, supervision at home, doing a home visit, making sure that the scenario is a good one, making sure that you've really vetted through that. And then you've got a screening. Again, interviewing and visiting the home like I mentioned, the standards for selection criteria, and then making sure, again, that you follow up because you want to stay in touch with these families, making sure that they're well trained in ways that you need them to be, supervision and monitoring by the school of the families, and how are you going to report and handle any problems and allegations. On the international front, United Educators has done a study on students traveling abroad, and something like 60% of all sexual impropriety cases of students traveling abroad happen when they're staying at homestay families. And so you've got to be aware of some of those potential risks in our own world. Know, too, that there's something called a J-1 visa some of you may be familiar with, and it's when a student is coming just for a year and you have an outside sponsor. J-1 visas have very specific requirements that must be met with homestay programs about who has background checks done within a family, all of that kind of thing. I've got a document on it. Happy to send it to you, but it sort of outlines some of those things. That could be considered a base standard of a duty of care. So you're going to want to be able to meet those standards through your own program. Some of the other issues that come up I won't get too deep into, but if you want to email me or ask some questions, I'm happy to help you on these fronts. Employee serving as host families does come up. Again, these day-to-day issues, medical information releases and the authorities there, those are big questions. And then the hold in loco parentis, making sure that the permissions are solid enough so that they can provide permission for the student to do things. And then you want to vet the students. In this particular scenario that we've got here, we're looking at a student who, might be really having some serious mental health issues. You want your vetting process to be at least as rigorous as it is for domestic students. You want the appropriateness not only of the school for the student, but vice versa. And particularly in a situation where you've got a host family scenario or something like that, it's a unique situation that most day schools aren't dealing with. Authentication of transcripts and references, full education and disciplinary records. You really want to make sure that you understand the student's background because I've talked to a couple of attorneys out there who are seeing some issues come up where, one of the reasons that the parents are potentially sending the student abroad is that they've had some pretty profound difficulties or mental health issues before they've come to our schools. This is sort of a list of some of the things that go wrong. I know those of you who deal with this probably have a good running list in your own head, so I'm not going to belabor it so we can move on a little bit. Although you do want to have a game plan for when things do go wrong. The other students seem fine for now. However, you cannot get a hold of the vendor who helped you recruit the other students. Now what? This is a big issue, I think, that a lot of our schools are seeing. When you're working with this third-party vendor, some of them are domestic corporations, some of them are international corporations. Really pay attention to these contracts. As I've talked to schools, I realize they don't necessarily know what's in the contract, particularly if that third party is coordinating those housing arrangements, coordinating the host families, things like that. Even if they're taking on the full liability, you really want to know what it is that they're doing, how it is that they're doing it, because if something happens, beyond the legal, just ethically and morally, you're going to be devastated. So making sure that these are good, reputable vendors, that you're doing your due diligence, you're doing, your reference checks, you're making sure that they're functional companies, and that contract is fully enforceable, particularly for vendors who are out of the country, making sure that you can enforce this agreement, and being very clear as to what you expect them to be doing and the liability that they're taking on. You'll see that very key term, indemnification provision. That provision is what says if they mess up and you get sued, they're going to be protecting you in the event of that lawsuit. And oftentimes it's mutual, so that if you mess up somewhere in the course of overseeing the student at the school and they get sued, you're going to be protecting them as well. And the insurance is also very clear. Some of these vendors are smaller. You want to make sure that they've got the insurance to cover you in the event that something happens, not just to the couple students that they might be helping, but their overall program, and really checking to see if it's appropriate given what it is that they're engaging in. Okay, Karen, I'm going to pause there for a minute. Do we have any questions on this international student front?
Yeah, we actually do have a couple of them. Philip is asking if you know whether a student on an F1 visa can stay with a host family instead of in a dorm.
Yes, they can. There's nothing in the F1 student regulations, at least not that I've ever seen or heard of, that would require an F1 student to stay in a dorm. And it's really not all that uncommon in these boarding programs for F1 students to be in homestay programs, particularly over the last couple of years as these have come up.
Okay, we actually have several questions that came in about record keeping. If you'd prefer to wait until the end for that, I can hang on to them.
Yeah, let's circle back around on those because we're going to cross into the ADA, and I know people are very interested in that, and I just want to make sure that we can get through that topic.
Sounds good.
Okay. You have accepted a 6th grade student for this academic year. The family returned the contract and paid the tuition in full last week. Now the mother's in your office handing you an IEP that is 4 years old and saying that she wants the school to meet it. What do you do? As everybody on the phone probably knows, the ADA applies in a variety of ways to institutions, and in our schools' cases, we're places of public accommodation. We're required to provide reasonable accommodations for students with disabilities. They do not apply, the ADA does not apply if you're truly a religious institution, and under the ADA that's a pretty fact-specific inquiry. Some schools have had litigation on this front about whether they're truly a religious entity. It's not just based on whether you're exempt from filing the 990 or something like that. So if you're thinking that you're covered in that way, make sure before you decide not to follow the ADA and some of the requirements that are in there. If you take federal financial assistance, and that can be in the form of funds, or it can be, in the form of, receiving library materials or taking money for school lunches or the school milk program. You're also required to meet the 504 requirements. That's sort of a forerunner to the ADA. And 504 can apply to religious institutions. So if you're exempt from the ADA because you're a religious institution, let's say you participate in the school lunch program, 504 will apply. And a lot of the same definitions cross over between 504 and the ADA. So while it might be tempting to maintain your personal thoughts, really pay attention to this because even if you're a religious entity, 504 still may apply in your schools. The new ADA went into effect in 2009. Here's a definition of disability under the ADA. But the big change that came into effect in 2009 and that we've seen rolling out with regulations over the last few years is that this is no longer, who's disabled is no longer supposed to be a long, sort of drawn-out affair. It used to be that in litigation, the definition required somebody to show that they were severely or significantly limited in a major life activity. And what Congress said in revisiting the ADA, they said, this should no longer be an extensive analysis. Now it's going to cover a whole bunch of things. It does cover severe allergies. Your peanut allergy kids are covered under this. Cancer, even if it's in remission. And the House Committee report specifically stated that they anticipate better protection for those with learning disabilities because there was a lot of back and forth on this. Students taking the MCAT weren't given extra time because they said, well, they've done so well, so clearly it can't be that significant of a learning disability. But they're not taking into account the fact that the learning disability did exist. So be aware that this is a change in the ADA. So if you've been doing this for a long time, and you haven't thought about the ADA for a while, know that it really does apply to a lot of students in our schools. What do you have to do? What do you need to do under the ADA? You, again, have to provide these reasonable accommodations. It may not unduly burden school resources, and that's the reasonable part. Is it reasonable? And the answer to that is, does it unduly burden school resources? And that's looking at financial and staffing. Or does it fundamentally alter the program? So if you're an IB program and a student wants an exception to the language requirement, that's pretty much fundamentally altering your program. Or if you're a military school and you have a very strict disciplinary and honor code and the family wants an exemption from that, that's fundamentally altering your program. It does not have to be the preferred accommodation. It can basically meet the same end. What is reasonable for one student might not be reasonable for another. Their disability might not be the same. And again, it must be reasonable and necessary. For 504, the standard is not quite as high. It's a minor accommodation. It's not a reasonable accommodation, but note that under 504, you need to have a 504 plan. It's not quite like an IEP, but it's still a plan. So you have to have a written plan and somebody actually appointed to oversee it. So from the internal policy standpoint, one thing that can be very helpful for schools, particularly going into the application process, is that you're very clear on what your accommodations policies are, who receives requests for accommodations, noting that just because a student's had an accommodation at a previous school doesn't mean that your school is going to necessarily do the same thing. What kind of documentation that you require for anybody making an accommodation request, who's going to review that information, who will make that decision, who will ultimately communicate with the family, and how is that communication going to take place. All of these should be part of your internal policy, and you in the admission office should know the answer to every single one of those questions. And again, when families ask for that information, or just to have it up front to say, to all families, here is how we handle accommodations requests, and to note that you're not necessarily going to meet the accommodations of the previous public school or even the previous independent school. You do want to document your entire process, from when you get the information, how that conversation is had, what your plan is for working with the family. Although 504 requires a plan and the ADA does not, you want to have a plan in place to document up how that relationship is working, and have a method for ensuring that the school is meeting its obligations, and that check-in with the family. And that's a really important part. I'll say it again, check in with the family, because sometimes the situation is leaving the rails, and that's how you lose. That's how you lose a potentially very good family. The communication is not wide open. I will say one thing that I've been hearing some of lately in the field are that as students move up through a curriculum and the way that a curriculum is managed change, so maybe they're going from the lower school to the middle school, or the middle school to the upper school, and the school wants to change accommodations slightly, or the teachers say, well, it just doesn't work as well in the upper school, you need to figure out how those accommodations are still going to be made. You can't just drop the accommodation. So, asking the question. This is my favorite question from admissions officers. I think I've heard it at every admissions thing I've ever done. And under 504, you cannot ask the question. If 504 applies to you, there's a specific guidance under 504 that says you cannot ask this question, and that's what higher ed runs into quite a bit. However, under the ADA, it's not as clear. There's some guidance out there for those who might come in and audit you and whatnot that says, one could at least infer that you shouldn't be asking the question. However, it's not particularly clear, and I know for a lot of schools you really do want to ask. The problem is, once you have this information in your files, in your notes, you've opened yourself up to a potential discrimination claim. And you need to sort of think long and hard before you really get that information, because once you reject that student, you're wide open for that. In some states, like California, if you turn down a student with a known disability, you actually have to self-report to the State Department of Education. So this information, is potentially a huge issue for you. And, all the variations on the question, I'm lumping all of this together, whatever magic language you've come up with. Do you need reasonable accommodations? Have you done any psychometric testing? Any of these variations on the theme kind of all fall into this category of, have you flagged a student as disabled, and are you using that to basically screen them out of your admissions process? I will tell you the other thing that's happening out there is, I know of at least one group that has been visiting our school's websites, has called a number of admissions office, really digging down into how do our schools work with students who are presenting with a disability, particularly physical disabilities. So as you're thinking about asking these questions and what you do with this information, think about what it looks like to those who want to point to you as elitist or as exclusive. Bear all of that in mind when you're doing these things. If you're committed, you're saying, no, we really want to ask this question on our application, work with your school's legal counsel, because it's also not a place where you as an individual, if something happens, you want to say, some other schools do it, so I put it on there too. You really want to have your attorney looking at your application and helping back you up on the decision to put it in there. They can also look at state law, because state laws often have some sort of a disability act that might keep you from including this question on the application just from a state law perspective. So be aware that this is not an uncomplicated question, but it's not an unusual question either. And depending on your attorney, you're going to get a broad range of, okay, so if you don't ask it in your application, when can you ask it? Some attorneys say, you can do basically a conditional acceptance letter and say, that says, this offer of admissions is conditioned on our being able to meet any necessary reasonable accommodations. If you have such needs, please, contact so-and-so. This is what we're going to need in writing in order to make this determination about whether, what we can do, whether it's going to be reasonable, that kind of thing, and it starts the dialogue going. You want to, again, because you want to try to document this whole process, you really want to get that documentation in there someplace, and you're going to be required to enter into that interactive dialogue about whether you can make those reasonable accommodations. So know that that's coming down the pike. So, again, some attorneys will say, yes, you can ask it. If they're saying that, you want to work with them to make sure your language is good and clean. Others are going to say, no, please don't ask for that information. And that's when you say, okay, well, when can we gather this information? Because we're going to need it before the student shows up on the first day of school. And we would rather start, having a good constructive conversation so that we can make sure we're a good fit for that student. Okay, Karen, what kind of questions have we got on this one?
Okay, actually we have several. We do have one request to clarify exactly what the question is.
Sure. The question is, does the student have any kind of a learning or other disability? Often for schools, it's not a question of a physical disability. It's whether it's a learning disability and basically how much accommodation they might need and what tests the family has that sort of document that learning disability.
Okay, thank you. The next question is, if you deny a student because you don't feel the accommodations are reasonable, what kind of documentation do you recommend?
Again, this is sort of your volcano moment. So you've got, you know that the student has some sort of a disability. They ask for the accommodation. If you're engaging in interactive dialogue, you don't necessarily have to do what they're asking you to do. And particularly if you feel it's unreasonable, there might be other things that you can do to meet it. Have as much of that interactive dialogue as you can to see what you can work out with the families. And again, this is where creating a plan is a good idea, because you can also say, okay, these are the things that we can reasonably do. What can you possibly do to make some of these other, bridge some of these other gaps that are in the student plan so we can make this work in the best interest of the student. So, hopefully it's not this is the reasonable accommodation they want, and you're like, oh, no, sorry, we can't do that. You really want to engage in that conversation, at the very least, so that if you decide that it's not a good fit for the student, you've got a record of that conversation, you know what they were looking for, you even probably have documentation that they don't want anything different than that, and you just feel like that's unreasonable. In that process, if ultimately you're going to say, no, I'm sorry, this isn't going to be a good fit, or we can't do these reasonable accommodations, you really want to have your attorney sort of helping you a little bit behind the scenes just to help you document it up in case something comes of that. And again, that interactive dialogue is going to be key with the family, and the families really appreciate it.
Okay, we're asking for also another clarification that a religious school not accepting federal money is not bound by ADA in any way, correct?
It totally depends on whether the school is truly a religious school, which under the ADA has its own separate test. So you want to have your attorney looking at that test and looking at your school to make sure you truly qualify as a religious organization under the ADA. Some schools have a tie to a religious organization, or they're nominally Episcopalian, or they're nominally a Friends school, but because of the way their program has developed and the way they're governed and some other things, they're not truly considered a religious entity under the ADA.
Okay. The next question is, if the IEP is 4 years old, does the school have the right to ask for an updated one, or is 4 years old still current?
That's an excellent question. 4 years old is pretty old, and the school can actually set its own policies on this front. So So the mother comes to you and says, oh, I've got this IEP and you need to meet it. You sort of back up the conversation and say, okay, this is our policy for making accommodations. This is who you should talk to. We're going to require certain kind of documentation. We need this kind of updated test or testing file. And, look at what's reasonable. For a lot of schools, say the high schools, you're looking at what the College Board requires, particularly for the standardized testing at the College Board level, because that's the standard the kids are going to have to meet as they go forward to the SAT or looking at the ACT or those other models. But you can actually take control of the conversation at that point. You don't have to just take the IEP and sort of walk stunned out into the hall. And it's why it's good to have your internal policies and procedures in place before the issue comes up.
Okay, thank you. We've had several questions about whether if the family volunteers that their child has a learning difference or disability, can they then ask for documentation?
Sure. Once the family raises the issue, and this is certainly the way it happens in the employment context too, once somebody self-identifies as, having a disability of some kind or whatever, you can start that interactive conversation, depending on when it comes up or whatever, but you don't necessarily have to push it off because they've already come to you with this information. And, and I'll say I was on the board of a school that just served students with learning disabilities for 7 years. So I can tell you that for most families, they really want to ensure a good fit. And they're not trying to create an issue. They want to make sure that their student is going to the right school. So if a family approaches you with this and says, here's our scenario, this is what we're looking at, you can start to engage in that interactive dialogue and, and talk about, well, what are the potential needs here?
Okay, Paul is asking, does the disclosure of a disability not mentioned during the admission process, can a school change its decision in that case?
You wouldn't do it just based on the disclosure of a disability. You might do it if, after interactive dialogue you determine that you can't make reasonable accommodations for the student, which sort of refers back to the earlier question. But, unless you're asking a question on through your admissions process that says, please disclose, any kind of physical or learning disability that might require reasonable accommodations, here's the documentation we need. You're asking that question after meeting with your attorney, and your form might say any key pieces of information that are left out might cause a revocation of an admissions offer or something like that. But generally speaking, if you're not asking that or you don't have a structure in place, you're not going to back out just because you found out that a student has a disability of some kind.
Thank you. We have someone asking if you can ask on the application if the student has ever been referred for an IEP or an educational evaluation.
Yeah, that's sort of, again, a twist on the same question. This falls into sort of the variation on the question themes. All of those versions that might sort of tease out whether a student has a disability or potentially has a disability fall under this. If you're going to ask it, you really want to work with your attorney before you put it live on your application.
Now, are these requirements and rules, do they apply to summer programs where there's not an admission process?
Yes, they sure do. When you have places of public accommodation, it applies to schools, it applies to camps, it sort of applies all over the place. So you need to be aware of these ADA issues in whatever program is happening on your campus or under your school's umbrella.
We have someone else asking if they should be employing a sign language interpreter for students with deaf parents. So this is more about accommodating the parents, Spanish speaking, sign language interpreters, things of that nature.
Sure. You must also accommodate parents. I actually just had a conversation with somebody about this yesterday. If parents are, particularly if they're hearing impaired, you can set requirements of, we'll provide this sort of interpreter as long as we know, at least 2 weeks before you're coming. It doesn't need to be. There are a lot of different kind of interpreting services you can use. There's some technological, there's some in person, there are different ways that you can do it. So again, you have a little flexibility there. But yes, parents coming onto your campus is another area of accessibility that you need to be aware of. It's not unlike your website and making your website accessible.
Okay. Next question is from Mike. He's asking if a student's family has disclosed a learning difference and we determine that he is admissible, but only if he enrolls in our fee-based learning support program, can we require him to take that program as a precondition for enrollment?
You know, it depends a little bit on how your fee-based admissions, how your fee-based learning center and those services are structured. Some of those things, just make sure as you're implementing them or you're building those out, you're getting your attorneys to look at them, because one of the concerns that I have when we start adding on fee-based services is that those should really be reasonable accommodations. So bear that in mind generally with those fee-based learning centers. If you're having interactive dialogue with the family, coming to that conclusion and making sure everybody's on the same page, there's definitely going to be a political element of how that conversation is handled. Just know that there's a little bit of tension there between having that be a fee-based service and whether some of those services should be reasonable accommodations. You know, it's in a gray area. I've never seen a school challenged on that, but it's one of those areas that I've got sort of a little twinge in the corner of my mind that I've got some concerns about for different schools. Is that possible that is a prerequisite? Sure. You know, bearing in mind that that fee-based center should be set up properly and not really be something that you should be doing as a reasonable accommodation generally.
Okay. Rita's asking, can you ask on admissions applications if a student is taking prescription medication?
I'm sorry, could you repeat that, Karen? You broke up just for a second.
Sorry. Can you ask on an admission application if a student is taking prescription medication?
You know, again, it falls into that variation on the question theme. You might ask it if you need to if the student is doing a visit, you know, if the student has medication that needs to be administered while they're at the school, because it's reasonably necessary for the situation the student is going into. But, you know, that's another question that tends to tease out these kinds of issues. And, you know, it can throw up that discrimination flag. Karen, are there any other questions that we should get to on any of the other topics? I'm just aware of the time and that it's just now 4 o'clock.
Absolutely. We had a couple questions on keeping interview notes.
Right.
Keeping them in the core database and what should and shouldn't be said about an applicant in notes.
Yeah, the interview notes, at least for a while when I first started, there was a lot of speculation about the admissions officer's secret notebook, what kind of notes you could take and things like that. Be aware that anything you write down in the admissions process and anywhere you write it down, even if you keep it in the trunk of your car or under your mattress or wherever, is subpoenaable. So don't write anything down that you don't want to show up in the newspaper, potentially out of context the next day. And wherever it's kept, it's accessible, because what the subpoena will say is any and all notes taken by any current or then in employment with the school for X school years. And there, it encompasses everything. So it can be any teacher who wrote down any notes about observing a student in a class. It covers that whole broad spectrum. So be aware that anything you write down can come under that microscope.
Deborah, thank you so much. We've reached the top of our 4 o'clock hour, and I know that everybody's time is precious here. So if you'd like to wrap it up, I will go ahead and chime in afterwards with my wrap-up as well.
Super. Well, you all have my contact information. Please do feel free if we haven't talked about something today that you'd like to speak about. I always tend to prepare more information than I can possibly share in the session. But I'd love to hear from you. Feel free to email, feel free to call, and I'm happy to help in whatever way I can. And if I can't help you, then I can hopefully refer you to somebody who can. So thank you so much for joining us this afternoon, and Karen, thank you so much for facilitating.
I want to thank our audience for tuning in, and a special thank you to Deborah for providing us with this insightful webinar. Just a reminder, a recording of this presentation will be available for a limited time for NAIS members on the NAIS website. And as Deborah said, if we did not reach your question today, please feel free to contact her directly. Thanks again, and have a wonderful day.